All right, good afternoon, everyone. Thank you for taking the time this afternoon to be with us for this Antitrust Webinar. My name is Andrew Terrell. I am the NRMCA Staff Liaison to the Business Advancement Committee, along with Gary Mullings. The Business Advance Committee is a new committee at NRMCA dedicated to the financial performance of the ready-mix concrete industry. Of course, the foundation of any effort to advance financial performance of an industry must begin with a sound understanding of the guardrails of antitrust compliance. And so to that end, we're pleased to welcome Leo Casera to present on current antitrust regulations and to provide some guidelines and do's and don'ts around antitrust. Leo's a partner at the law firm of Shepherd Mullen here in Washington, D.C., and he's provided antitrust advice to construction material suppliers of all types. He's represented several ready-mix concrete companies on issues arising from mergers and acquisitions, civil litigation, and government investigations. We had the privilege of having Leo present at Concrete Works last fall, and we're excited to have him here to present today. Couple of housekeeping items before we get started. Please keep yourself on mute. We have defaulted everyone to mute to minimize background noise and static. So please keep yourself on mute. Secondly, if you have questions, please either submit those in writing and I will take them and monitor them, and then or you can hold them until the end when we have questions and we can come off mute. Finally, we will be recording this session, and the recording and the accompanying PowerPoint will be available to NRMCA members in the future. With that, Leo, I will turn it over to you for this presentation. Thank you very much.
Sure. Thanks, Andrew, and thanks, Gary, for having me here today to talk about antitrust. It's certainly a topic that's top of mind for a lot of folks in the ready-mix industry and really all industries today. So I'm going to talk about a number of general concepts, do's and don'ts. If you have questions, I'm going to save some time at the end for questions. And obviously you can submit questions as the presentation is going, or reach out to me directly afterwards with questions. So, antitrust is a very big area of law. It's the laws that govern free market competition in our economy. And so there's a lot of different ways that antitrust law can come into play when you start to think about all the ways that you compete for business out in the market. And so one of the things I like to do whenever starting one of these presentations is talk about what's on the minds of the antitrust enforcers at the federal agencies, the FTC and the DOJ. Because when you're talking about competition in any market, there's so many different directions that can go. Understanding what is at top of mind for your enforcers gives you an idea of where they're looking at potential issues and where you should be worrying about compliance. The head of our FTC is Lena Khan, and I put a couple of quotes up here about some things that are on her mind. And the first quote here is, a comment about workers and the amount of that they're getting paid and the working conditions that employees are dealing with in today's economy. And the second quote here is about inflation. So if you think about what you're reading in the headlines over the last couple of years, there's a lot of articles out there about inflation leading to higher prices across all industries, and also a lot of concern about wages for workers not keeping up with that, right? And so your antitrust enforcers out there today are thinking about the antitrust laws as a way to potentially find some of the causes for that with respect to companies that may be doing things that are violating the antitrust laws and contributing to higher prices or lower wages. And this is the head of the DOJ's antitrust division with a similar quote, talking about, again, high prices and lower wages and the problems that our economy is dealing with because of that. So these are the kinds of things folks are looking for or looking to solve with antitrust laws today. So when we talk about antitrust laws, what are we talking about? There's a lot of antitrust laws out there. These are sort of the main federal antitrust laws that you would likely be thinking about and concerned about in your day-to-day activities in your ready-mix business. Sherman Act Section 1 is a federal law that's been around since 1890. It prohibits agreements that unreasonably restrain trade. So two companies getting together to reach an agreement, two or more companies getting together to reach an agreement that restricts competition. So price fixing, market allocation, things like that would violate Sherman Act Section 1. Section 2 of the Sherman Act prohibits monopolization and attempts to monopolize. So one company with a lot of market power in a particular market, abusing that power to foreclose competition. So unlike Sherman Act Section 1, one company on its own can violate Sherman Act Section 2. Then you have Clayton Act Section 7, which prohibits mergers between two or more companies that substantially lessen competition or tend to create a monopoly. FTC Act Section 5, which very broadly prohibits unfair methods of competition. We'll talk more about that. And the Robinson-Patman Act, which prohibits price discrimination. So selling the same product to the same type of customer at different prices without a justification. So who are your enforcers of the antitrust laws? Well, you've got a lot of different directions that you could be facing an antitrust issue, right? At the federal government level, there are actually two departments that enforce the antitrust laws. You've got the Department of Justice and the Federal Trade Commission. In most countries, you have one agency that handles enforcement of the antitrust laws. The US is unique in that we have two agencies, the DOJ and the FTC. They can both come after you for antitrust violations. Each of the 50 states has their own antitrust laws. So the laws I just talked about in the last slide are federal. Most states have some version of the same types of laws. There may be variations in how the state approaches it under their law versus how federal law approaches an antitrust issue. So each state has an antitrust law you've got to worry about, and the attorneys general in each of those states can bring investigations or cases. And then, of course, you have private parties, right? Your competitors who feel that you've unfairly competed with them might decide to bring an antitrust claim against you. Customers who feel like you've done something unfair and they're paying higher prices or otherwise being disadvantaged might bring cases against you. So a lot of different directions where antitrust issues could be directed at you. All right, so why should you care about the antitrust laws? The stakes are extremely high, right? Antitrust violations at the federal level are felonies. If the government thinks that you violated Sherman Act Section 1 and you fixed prices, you've rigged bids, you've allocated markets, they can pursue that criminally. They can go after the companies that are involved and also the individuals. For the individuals, fines can be up to $1 million and the sentences can be up to 10 years. For companies, I think the largest criminal fine is over $900 million. So there's quite a bit of money at stake in these types of issues, and that's just criminally, right? So separate and apart from criminal, you can face class actions, you can face private litigation, and folks can pursue damages against you. And if they establish damages, those are automatically tripled under the antitrust laws. So a lot of high stakes issues wrapped up in the antitrust laws. These categories of antitrust violations are the ones that can get you into, traditionally, these are the ones that can get you into criminal antitrust trouble. The Department of Justice traditionally pursues only these types of violations as criminal, as having criminal liability. There are some other ones we're going to talk about that are newer, but these are the ones you particularly want to avoid. Price fixing, again, agreement between competitors to fix prices. This could be any aspect of price. It doesn't have to be your list price. It doesn't have to be your net price. It could be a rebate. It could be a discount. It could be a discussion about the timing of a price increase. Anything that relates to price could be a fee that's added to your price, right? So anything that involves or relates to price, you don't want to talk about it with a competitor and reach an agreement about it with the competitor, because that could be price fixing, could subject you to criminal liability. Market allocation would be an agreement between competitors to allocate markets. And this could be an agreement that, you reach out to a competitor and you say, I'm going to keep my customers and I'm not going to go after yours. And then in exchange, you stick with your customers. You don't come after mine, right? It could be a customer allocation, or it could be a geographic area allocation where you say, I'm going to stay in these counties, you stay in those counties, and we'll stay out of each other's turf. Or it could be specific types of products or services, right? We'll provide this type of concrete, you stick to other types of concrete. Lots of variations on market allocation. All of those would be violations of Sherman Act Section 1 and subject you to criminal liability. Bid rigging would be the other big category out there. And that's when competitors get together, they agree on who's going to win a bid, what the bid amounts might be, any other aspect of a competitive bidding process. Now, how does the government or a private plaintiff establish that a conspiracy actually happened, right? Sometimes a company will say, or be under the misconception that if they don't literally say the words, I agree with their competitor, they can avoid all these problems. And that's not how the law works. Well over 95% of these types of violations are established with what we call circumstantial evidence. Circumstantial evidence just means companies are behaving in a way that's consistent with agreement. And when you add all that up, a jury or a judge decides, you know what, it kind of looks like you've agreed. We're going to let this case move forward. That's typically how these cases progress. So it's a very rare case that competitors would say, let's fix prices. Yes, I agree. Or let's fix prices. Let's put that in a written agreement and I'll sign it. That doesn't really happen. So it's not the case that if you simply avoid saying the words, I agree, you can avoid these problems. You start to exchange price information. You start to have a lot of meetings where you're discussing sensitive issues. That starts to look like agreement. All right, so let's talk about some ways that folks in the ready mix industry have gotten into trouble in the past, because I think this helps kind of crystallize what the risks are and what others have dealt with. And I'm going to go through a number of actual real world cases that have happened over the years in your industry and in similar or related industries. In 2004, there was a conspiracy or alleged conspiracy between 5 ready-mix concrete companies in a particular state, and DOJ uncovered this conspiracy, pursued criminal action against those involved, and the result was that 10 individuals went to prison and served sentences ranging from 5 to 27 months. 4 of those companies paid fines totaling $35.1 million. 1 company alone paid $29.2 million. 4 companies ended up being suspended or debarred. So this is another important penalty that can happen when you've been found or convicted of an antitrust violation. You can actually be suspended or debarred from government contracts. And if your business depends to a significant extent on government work, this can be what folks refer to as the death sentence for your business, because if you are suspended or debarred, you're not going to be able to go after that kind of work. So again, just very high stakes when it comes to antitrust. And of course, after all the criminal proceedings, there was a class action, and the collective settlements were over 50 million. How did this particular conspiracy or alleged conspiracy work? The allegation was that customers originally were pitting the ready-mix concrete competitors against each other, obtaining significant discounts. And so what happened? The competitors said, well, we'd really like to stop this price war and all this discounting. Let's get together and talk about that and figure out how we can stop this. And when they met, they talked and they agreed that no one could discount more than $5.50 off the list prices. So again, any discussion, any agreement relating to any aspect of price, whether it's the price, the discount, something else, can get you into trouble when it comes to price fixing. Now, interestingly, there was one company that refused to join the conspiracy. So most of the competitors in this particular area got together, reached this agreement. Well, there was another company they invited to the party, and that company said, you know what, I don't think this is right. I'm not going to do this. They went a step further. That company then went to the DOJ and said, I know there's a conspiracy out there that's happening in my market. I'm not okay with it. DOJ asked them to cooperate and wear a wire, and they did. And so what you had happen in that case was that particular individual at that company wore a wire and then went back and started having conversations and meetings that were recorded. And that's how DOJ built evidence about this particular conspiracy. So one thing you'll see as we go through these slides, there's a lot of different ways that the government learns about these things. This is one way. Somebody from within or somebody who's been invited and doesn't want to join decides to cooperate against everyone else. And again, very high stakes here. A lot of folks going to prison, a lot of folks paying a lot of significant fines. Another interesting thing about this, the companies involved with this particular conspiracy, there were 2 individuals involved who refused to plead guilty. Okay, so even with the wire, even with all this evidence, 2 individuals said, you know what, I'm going to go to trial. I'm going to test these allegations. And their argument was, well, you know, yeah, we went to a lot of these meetings where a lot of things were discussed, but we never said anything, right? We sat there silently. We didn't say the words, I agree. We didn't say anything at all. Frankly, we just sat and listened because we wanted to know what all these other people were talking about. And that argument didn't work. So this is an important lesson for folks. Again, when it comes to conspiracy, you know, not saying the words "I agree" is not gonna cut it. And so what the court there found was, what the jury found was, by being in those meetings and not saying, and not leaving the meeting and not saying you didn't agree, you were basically, you know, part of that agreement, right? You sat there, you listened, you didn't object, you didn't walk away. And so that was enough to establish that you were part of that conspiracy. Another company had 2 individuals that were not prosecuted, no fines, no jail time, because they cooperated with DOJ and others. They cooperated with DOJ against the other conspirators. And DOJ has a program called the Amnesty Program that allows somebody within a conspiracy to come forward and essentially confess their role and agree to cooperate in exchange for immunity from criminal prosecution. So this particular company and the individuals here came forward, claimed amnesty, and no one went to jail, no one had to pay any fines. And typically, only the very first company that comes forward is going to be able to claim this type of immunity. This is really the main tool that DOJ has to uncover price fixing conspiracies, market allocation conspiracies, other types of conspiracies. According to their own stats, well over 90% of criminal antitrust fines from 96 to 2010 began with an amnesty applicant. So that means if you're talking to somebody about fixing prices, if you're talking to somebody about allocating markets, you know, it's going to be the person that you're talking to that's going to come forward and get you in trouble, right? If you're going to be found out, that's how it's going to happen. It's a very powerful tool, and you know, they continue to uncover antitrust violations every year using the amnesty program. So that's 2004. In 2009, we saw another alleged ready-mix concrete conspiracy that caught DOJ's attention and resulted in folks going to prison and paying significant fines. In 2009, you had a group of companies that reached separate bilateral agreements. So unlike the example I just went through before, where you had a number of competitors all get together and reach one collective agreement, the example we have from 2009 involved separate companies, each with separate one-on-one agreements to allocate markets and fix prices. Same thing, there's no difference whether it's, you know, a collective group agreement or a series of one-on-one agreements. Either way, it still violates the antitrust laws. One of the things the companies here were alleged to have done is to allocate markets using zone maps that tracked actually what markets belong to which competitor, and then would just have regular one-on-one phone calls to figure out and talk and keep the conspiracy going. And again, the result was individuals were going to prison for up to 48 months and paying about $1 million in fines, and companies were also paying over $1 million in fines. And of course, there's always class actions that follow these investigations, and significant settlements were paid out through those. In 2016, we saw another example of DOJ pursuing an alleged conspiracy in the ready-mix industry. And this time it was a conspiracy that involved both ready-mix and cement. And so you had a vertically integrated company that produced both cement and ready-mix. And allegedly, a cement salesman at the vertically integrated company was used as a conduit to exchange ready-mix price increase information among a group of ready-mix competitors. So you talk about in different ways that companies and competitors can reach agreements. We started with all competitors getting together and reaching one collective agreement. We had another example of a group of one-on-one conversations between competitors. This one presents what's called what we call a hub and spokes agreement, right? So the competitors don't directly talk to each other or to any other competitor, but they pass information through somebody who's vertically related to them, right? They're passing information through a cement salesman in this case. All of these different examples all can violate the antitrust laws and subject you to criminal prosecution. And again, significant amount of criminal penalties. Now, the risks today are probably higher than ever because following all those examples, and even with cement and concrete on the minds of our government enforcers, in 2019, the DOJ formed the Procurement Collusion Strike Force. So the whole goal of this group, this strike force, is to target and locate potential antitrust violations in government procurement. So what they're doing is having this interagency partnership, and they're going out and training and educating government procurement officials on how to detect antitrust violations, things like looking for odd bidding patterns, looking for strange pricing patterns, right? To be able to detect when they may be subject to an antitrust violation. And efforts like these are just raising the stakes for folks in ready-mix and other construction materials industries, because people are very attuned to antitrust and looking for them specifically. I think at one point, the government said that about 1/3 of their open antitrust investigations were coming out of this effort. So it's been a very successful initiative for the federal government and the antitrust agencies. And we see that with some of the more recent cases that are coming out of the government. In 2021, DOJ alleged that providers of concrete repair and construction services to public schools in Minnesota conspired to rig bids from 2012 to 2017. This was a case that came out of the Procurement Collusion Strike Force efforts. And this is a run-of-the-mill bid rigging operation, according to DOJ. That's what the allegations are. DOJ alleged that defendants communicated and agreed on what bids they would submit. The winner would be lower than everyone else, and the others would intentionally bid high and lose. Pretty simple alleged bid rigging conspiracy. In September 2021, an individual pleaded guilty and has a recommended sentence of 8 to 14 months and a $20,000 fine. Now, that individual is cooperating with the government, and we recently saw in 2022 another indictment coming out of the same set of facts, the same investigation, but this time it expanded. DOJ expanded its net. They sort of expanded the conspiracy to additional counties and cities within Minnesota based on the results of the ongoing investigation. So this is a sort of a sequence of events that you see frequently where one person, one company comes forward, they start cooperating with the government learns more, the net expands, and it keeps going from there. another recent example involving Contech, company that created aluminum structures for projects for Department of Transportation, allegedly rigged bids from 2009 to 2018. Contech pleaded guilty to this and paid a fine of $7 million and restitution of $1.5 million. The key individual that allegedly was involved went to trial, and a jury convicted that person, who is or will be serving an 18-month sentence. So for you all, what are the takeaways from all this, right? Ready mix and cement and other construction materials are certainly top of mind for the federal government when they're thinking about antitrust violations, and they've historically been paying attention to ready mix, looking at the ready mix industry, and I think that scrutiny has only gone up over time, particularly with the procurement collusion strike force efforts. So if you find yourself in a situation where you're in a meeting, you're in a room, you're somewhere, you're at an industry event, and folks are talking about, your competitors are talking about prices, are talking about other competitively sensitive issues like discounts or rebates, whatever it may be, you don't want to be in that discussion, right? You want to leave that discussion and make sure that, a year, 2 years, 3 years down the road, if somebody's trying to remember who was at that meeting, when did it happen, what was discussed, someone's going to be able to say, yeah, I remember that so-and-so actually left, right, before we started talking about a certain topic, or left as soon as this certain topic came up, right? So you want to get out of that discussion, and you want to have it be memorable that you left, that you didn't agree, and you want to get your company counsel involved, right? You don't want to be worrying about where the lines are. You just want to get yourself out of there, get your attorney involved, and let your attorney kind of take over and tell you what the next steps are. Don't be like the example I gave earlier, where somebody just kind of stayed in the room, didn't say anything, and thought that by avoiding saying I agree, they were going to get out of the whole problem. That is just not how it works. Certainly don't want to say or do anything that suggests you do agree. So I would, make sure you don't go down that road. You don't want to actually go out and then change your price to match something that someone told you they were doing, right? And you don't want to be like in the hub and spokes example I gave, right? You don't want to be passing a message from one competitor to another on behalf of those two competitors, right? So don't find yourself in a hub and spokes situation. A lot of these types of conversations, I think, in the real world where you get into trouble, start off with a complaint, right? And what I mean by a complaint is, two competitors just at a trade association meeting, kind of complaining about the market, complaining about the economy, and the next thing you know, they're complaining about prices or profit margins. And then it just becomes a slippery slope. The next thing you know, you're talking about specific prices, specific customers, specific regions. And so I think what we see a lot is folks getting together, just sort of commiserating about a shared bad experience, and then it just kind of snowballs from there. So do what you can to avoid those types of interactions in high risk scenarios. Now, in the beginning here, I talked about sort of the traditional areas where the DOJ has pursued criminal antitrust violations, right? Price fixing, bid rigging, market allocation. Those have long been the areas where you see most of the criminal prosecutions. One new area relates to labor and employment related competition agreements. And in 2016, DOJ issued a document where they made a big announcement, and they said going forward, they're going to proceed criminally against naked wage fixing or no poaching agreements. So wage fixing is an agreement between competitors about what they're going to pay to a certain type of employee. So you might say, for this type of executive, let's just agree we're going to cap salaries at 100,000 or 50,000 or whatever it is, and we're not going to go try and we're not going to offer more than that to a certain level of employee. That's wage fixing. No poaching would be two competitors get together and say, look, I'm having a hard time recruiting good people out there to do a certain task. It'd be great if you stop hiring my good employees. And, if you do that, I'll stop hiring yours. Why don't we just do that? Make our lives easier. That's a no poach agreement, violates the antitrust laws. And now the DOJ is going to pursue those criminally. This is a hot area. We've seen a lot of action from the government over the last year or two relating to this. Prior to 2021, you didn't really see any of these types of cases coming up criminally, and now there's a ton of these types of cases and investigations out there. So it's a high risk area. Be very cognizant of what you're saying about wages or hiring when it comes to competitor interactions. So DOJ has been bringing a lot of these cases and investigations. Their first win came in a case in Las Vegas in March 2021, where they alleged that competitors that provide special needs nurses to schools got together and agreed to fix wages and not hire from each other. It's the first win because one of the defendants pleaded guilty, and so that's the first case where a defendant has pleaded guilty or otherwise been convicted of no poach or wage fixing in the U.S. We saw investigations and cases being filed and starting, and now we're starting to see them come to resolution and DOJ actually getting a win here. So this is certainly something they're going to continue to pursue, and getting a win, just makes the DOJ that much more excited about pursuing additional cases. The key evidence in these cases that we've seen, both in this one and other ones, it comes from emails, text messages, direct communications between competitors that are written down. And you can see here on the screen an email exchange where a competitor is literally saying, using the words agree, right? So what we're seeing in the cases that DOJ is bringing is similar evidence to this, where they feel like they've got a direct competitor to competitor communication written down that in their view shows a clear naked agreement, just either to not hire or to fix wages. One of the newer cases that's been filed is a case against 4 home healthcare agencies in Maine that allegedly fixed wages for home healthcare employees for 2 months in the state of Maine. So what's striking here is this is a very short-lived agreement involving a very small number of people in a very small geographic area, and nevertheless, DOJ is putting resources into going after these folks and pursuing this criminally. So just give you an idea of how serious this is for DOJ. It's not just the big, investigations, the nationwide examples, or examples where they think they've got a large number of workers in a large number of states. They're going after even the smallest examples of what they think are no poach or wage fix agreements. And again, the common theme is there are texts, there are emails direct between the competitors where they are saying that they are agreeing on something. And you see that on the screen here. And whenever there are DOJ investigations and cases, you also see private cases, class actions that result in large settlements. And we're seeing that as well in the no poach and the wage fix area. This is an example recently of a settlement where Booz Allen paid a large settlement to resolve an alleged no poach case for skilled employees at an intelligence operations center in England. Another example of a large class action, this time involving wage fixing, that resulted in a big settlement of $85 million, was a case against Cargill, an alleged 20-year conspiracy to fix compensation and benefits of poultry processing plant workers. One interesting allegation in this case was that the parties allegedly used a consultant to exchange information and provide the appearance of compliance and with antitrust law, but in reality, the allegation was that they were not doing that. So an effort to make it appear that everything was okay without actually having it be compliant with antitrust law. Another recent settlement here involved Jiffy Lube. In this particular case, you had a written agreement that one Jiffy Lube franchise would not hire someone who had worked for another Jiffy Lube franchise within 6 months. So those are just some of the examples. There are many, many other examples. For you all, some of the takeaways when it comes to labor and employment antitrust issues, you want to make sure if you're going to have some sort of non-compete or no-poach arrangement, the only way those can be okay is when they are ancillary to a larger agreement that has a legitimate pro-competitive purpose. And the no-poach in that instance would have to be very limited and go no further than what is reasonably necessary to achieve the larger purpose of some broader agreement. If you're going to go down that road, you're going to want to loop in an attorney to craft that very carefully for you. What the examples that I just went through are what we call naked no-poach or wage fix agreements. A naked no-poach or wage fix agreement is just competitor calling a competitor, and all they talk about is an agreement not to hire from each other, or an agreement not to set a certain level of compensation for a certain kind of worker, right? So that's not going to be ancillary to some other agreement. It's not going to be limited to what is reasonably necessary to achieve some other purpose. Again, if you're going to go down that road, you're going to want to loop in an attorney to make sure that that topic and that issue is crafted the right way. Another thing to watch out for is a reciprocal agreement that is rarely justifiable. And again, a common theme you see throughout the examples that I've gone through, and in other cases as well. Usually where you run into trouble and you have a hard time justifying anything is when two competitors get together and they have a reciprocal agreement. One guy says, I'm not going to hire from you. The other one says, I'm not going to hire from you either, right? Where you tend to see more legitimate agreements that are in line with the first two bullets here, it's often one way. One person doesn't hire from the other because there's some legitimate reason for that to happen. So a red flag should go up if you've got a reciprocal agreement on this. And of course, take caution in your text, chats, emails, other communications. Once you put something down in a text or an email that says you agree with a competitor on something, that's out there forever and could be the basis of a indictment or a complaint. And if you're not sure, call an attorney. So one interesting area of antitrust law is FTC Act Section 5, which only the FTC can enforce. And this very broadly prohibits unfair methods of competition. Okay, so there's always been this question about what does that exactly mean? That's a very broad statement. And I think most folks have understood FTC Act Section 5 to essentially cover all the other antitrust violations of all the other antitrust laws. If you violate some other antitrust law, you're also violating FTC Act Section 5. To the extent it extends beyond that, it's been a gray area. One area where we've seen cases in the past is invitations to collude. So if competitor X reaches out to competitor Y and says, hey, fix prices with me, competitor Y says, no, I'm not going to do that. Okay, well, they haven't violated Sherman Act Section 1 because there's no conspiracy, but the party that invited the other one to the price fixing conspiracy has actually violated Section 5 of the FTC Act. And we've seen enforcement actions over the years with those types of situations. Now, one interesting thing that happened in 2022 is that the FTC came out with this pronouncement where they identified 14 categories of conduct that in their minds violates FTC Act Section 5. And there's a lot of things on this list. And some of these are pretty broad, right? So you start to think about, if you just look at number one, practices that facilitate tacit coordination. Look at 2, parallel conduct that blocks or slows entry of competitors. Some of these things are extremely broad. We don't know exactly where the line is on these. FTC has announced that in their view, these are all violations of FTC Act Section 5. It's going to take them actually bringing cases or trying to create FTC rules to actually put this into effect. But they've kind of thrown the gauntlet down and said that they're looking at these things and thinking about potentially bringing actions to establish that these are violations of FTC Act Section 5. So kind of a gray area. FTC is pushing the envelope on this a little bit. We don't know exactly how far this extends or where the lines are. But if you're doing something that you think falls into one of these categories, you certainly want to talk to an attorney before you go down that road. So another area of antitrust enforcement that we get a lot of questions about is the Robinson-Patman Act, which prohibits price discrimination. The Robinson-Patman Act, at a general level, prohibits a seller from selling the same type of product to the same type of customer at different prices without a justification. Okay, so that's the general idea behind the Robinson-Patman Act. But when you get into the details, often people get very concerned about this, and it is something to be concerned about. But there are a lot of reasons why prices offered to customers can be set at different levels, right? There are many different justifications for legitimate price differences. So number one, you want to think about, are the prices actually different, right? If you offer, two customers may have different pricing from you, but maybe one has a rebate, or maybe you give a discount to someone, and then the net price ends up being the same, right? So think about, when you're thinking about price, sort of all the different aspects of price. And think about the products as well. The product may be actually different, right? If there's a different recipe for the concrete that you're selling to one customer versus another, that can be a basis for having a different price, right? If there are different ingredients used there, if there are different additives, if there's fly ash, if there's slag, all these things can be reasons why the product that you're selling might have a different price, because the ingredients are actually different. And the same goes for quantity, right? Like if someone's purchasing a greater volume, you can of course give a volume discount, right? So there can be lots and lots of different reasons why prices are different. The key is really the second to last bullet here, functional availability. I think whatever you're doing, if you're offering a volume discount of 5% when someone reaches a certain threshold, you want to make sure that that's functionally available to everybody. When someone else gets to that same threshold, you should also be offering them 5%, right? You don't want to be moving the goalposts for all the different customers. You want to have the same set of rules for everybody. And there's got to be an actual sale. There's got to be harm to competition. One important justification that's permitted under price discrimination rules is what's called the meeting competition defense. Okay, so if your customer comes to you and says, hey, company A is offering me ready mix at a price that's $5 better than your price, you're going to have to meet that in order to keep the business. You're fully justified in reducing your price to that customer to meet the competitor's price that the customer has told you about. Right? Even if that means you're now offering a slightly lower price to that customer compared to all your other customers. In order to meet competition, you can adjust your pricing so that you have a different level of pricing for a particular customer if that's what's needed to meet the competition. Now, one important thing you should keep in mind is you want to have a record of why you're offering or lowering that price to that customer. Okay, so companies do what's called a meet comp stamp or record, a little stamp, a little form. Maybe it's just a short email, something in the file that says customer A came to me, told me I needed to reduce price by $5 in order to meet lower price offered by competitor XYZ, right? Otherwise, 5 years from now, 10 years from now, nobody may remember what was going on, and it can be hard to establish the story that you know existed at the time. Robinson-Patman Act and price discrimination generally is an area that hasn't been enforced by the government for a long, long time. We haven't seen a whole lot of action on this from the FTC over the years. That has changed in late 2022. One of the FTC commissioners started talking about the Robinson-Patman Act and increasing enforcement on price discrimination. And we started reading reports in the Wall Street Journal just recently about new investigations from FTC allegedly on price discrimination by Pepsi. So we think this is an area that has renewed focus for the FTC. If we're reading about reports about investigations into a couple of big companies, there's probably going to be a lot of others out there that are confidential that we don't know about yet. So it's an area to be thinking about and make sure you're doing it the right way. Okay, we talked a lot about different kinds of conspiracies and joint conduct that could violate Sherman Act Section 1. But as I mentioned at the beginning, we also have Sherman Act Section 2, which prohibits monopolization. So that's one company, a monopolist with significant market share in a particular market that is doing something to abuse its power and prevent others from being able to compete. So it doesn't violate the antitrust laws to be big. You could have 80% of a particular market. You could have 80% of the ready mix business in your county, right? That is not a violation of Sherman Act Section 2, because the antitrust laws recognize that if you're a company that's putting out good products, providing good service, providing lower prices, more people are going to start buying from you, right? And your market share is going to grow. And so that 80% may be the result of some very competitive conduct. Now, the thing you want to make sure of is that you're kind of keeping it in that zone, right? If you got to 80% by doing all those things, keep doing those things. What the Sherman Act and the antitrust laws don't want is for someone to get to that, 50, 60, 70, 80% market share threshold and then say, well, now I can take my foot off the gas and start doing other things like having a long-term exclusive dealing relationship, requiring my customers to agree they're not going to deal with certain other companies out there. And so when you start going down those roads, combined with high market share, you can run into monopolization issues. One of the questions that was posed was, in periods of allocation, if you've got a supply shortage and you need to put your customers on allocation, what are the antitrust issues that you should be thinking about there? And I think you've got both monopolization issues and conspiracy issues that you got to worry about. So number one, if you're going to put folks on allocation, you want to do that unilaterally. Make that your own decision, your company's own decision, not something you're talking about with anybody else. And the best way to do it is to treat everyone fairly. But the real important thing from an antitrust perspective is that you're making your own decision. You're not agreeing with a competitor on how you're going to approach things. You're not agreeing with any customers on how you're going to approach things either, right? So let's say you agreed with one customer that they're going to get a little bit more than another customer. Well, now that other customer might say, well, there's a conspiracy here. These two got together and agreed during this period of shortage that they were going to cut me out, and now I'm out of business, right? And so to avoid that, don't have agreements with third parties about how you're going to do things. Make your own decision and just do it. Execute on it, right? On the monopolization side of the fence, you don't want to cut somebody out with a purpose of restricting competition in mind, right? You don't want to say, I'm not going to sell to this customer in a period of shortage because I really want them to go out of business and I want to help this other customer over here gain market share, right? You don't want to have competitive issues be the driver for your decision about what you're doing with respect to putting folks on allocation. So again, I talk about sort of the traditional areas where DOJ has pursued criminal antitrust violations. One change we saw last year was the DOJ bring its first criminal monopolization case in 41 years. And this was against a president of a paving and asphalt contractor who allegedly attempted to monopolize highway crack sealing services in Montana and Wyoming. The allegation was this person went to a competitor and said, I'll stay out of South Dakota and Nebraska if you stay out of Montana and Wyoming, and even offered to pay $100,000 to the competitor to compensate them for all the business that they would hand over when they exited Montana and Wyoming. Defendant pleaded guilty. This is the first criminal monopolization case in 41 years. Now, you may be saying, kind of sounds like a conspiracy. You know, I started by saying monopolization is typically one company doing something. This could have been pursued as a criminal conspiracy case under Sherman Act Section 1 based on the allegations. But I think DOJ is making the point that they're looking at monopolization as a criminal antitrust violation. And so, you know, specifically pursued this under Sherman Act Section 2. And we can expect more of that to happen in the future, more criminal monopolization cases. The head of the DOJ Antitrust Division, Jonathan Cantor, specifically made an announcement on this and said they've got the power to do it. There's a reason why, you know, Congress outlawed monopolization, and they're going to use their criminal prosecution powers to go after this. So I think we're going to see more of these. Last couple points, and then we can open it up for questions. If you find yourself the subject of or the target of an antitrust conspiracy, antitrust investigation by state or federal government, or if a case is filed, you have to retain documents. You cannot destroy documents. You cannot encourage other people to destroy documents, and you cannot manipulate or alter documents. We see time and time again, folks get into investigations, they get into cases, and they start, you know, often it's a moment of panic, and they start, you know, deleting things, changing things, telling other people to hide things. The government can come after folks who do that with separate criminal charges for obstruction of justice and other potential violations that are totally unrelated to antitrust. So, you know, in December 2020, we saw DOJ go after physical therapist staffing companies for alleged wage fixing, took it to trial, lost at trial, and jury acquitted the defendant of the antitrust charges. But, you know, DOJ said, you know, actually, this is a big win for us, right? Because they did get a conviction on obstruction because the person provided false testimony, was trying to coordinate stories with other parties. And so, you know, this person was sentenced to 3 years and a 3 years probation and a $10,000 fine, not for anything relating to antitrust, but simply for obstructing justice on the investigation. Another example in 2017 involving an auto parts price fixing, alleged auto parts price fixing conspiracy. An individual, once the investigation started, an individual went around to employees, told them, delete your emails, wipe your phones. That person was sentenced for 14 months obstruction, for obstruction. No antitrust violation. That person was not charged with an antitrust violation. So don't make things worse for yourself in a digital world. You're not, all this stuff, once it's written, once it's out there, it's there forever. You only make things worse by trying to change or hide anything. Similarly, you don't want to lie, right? If a government agent is asking you questions, this is common sense. Don't lie, don't bend the truth. Get your attorney involved. Your attorney's job is to kind of prep you for how to answer questions. And I'll just kind of put this up as the last slide, and we can open it for questions. But going all the way back to that first example I talked about on the ready mix conspiracy, this is some of the interesting facts that came out about how different individuals reacted when government agents showed up and started asking questions and talking to different people that were involved in that alleged conspiracy. And you just, you know, you don't want to lie, you don't want to volunteer things, get your attorney involved. You're going to be in a state of, you're not going to be in a right state of mind. You're not going to have dealt with this before. If you find yourself facing a government investigation, first call should always be to an attorney. Get an attorney involved. It's the attorney's job to prep you and make sure you don't do anything you're you're going to regret later. So I think that's a good place to stop and open it up for questions.
Thank you very much, Leo. Appreciate this presentation. I do have one question that came through, and if anyone else has questions, please feel free either to drop them in the chat or to ask them. But Leo, the first question had to do with no poaching agreements, and the question was, does this apply to suppliers or customers, or is it just between competitors?
Yeah, so on a no poach, right? Good question. So when you think about ready mix, the product, you're thinking about, I compete with other companies that sell ready mix. When it comes to these no poach antitrust violations, it's based on the type of worker. So you could violate antitrust law with a no poach agreement, even if it's between you and a company that's not a ready mix company, right? Let's say you need truck drivers, right? Well, you don't have to, it doesn't have to be another ready mix company that you're talking to that can get you into trouble on a no poach. You could be talking to a cement company, you could be talking to any number of other companies and reaching some kind of agreement not to poach each other's drivers. And that would get you into trouble. So it's not, for no poach and wage fixing, it's not a requirement that the two companies sell the exact same product. It's the requirement is the workers have to be the same kind of workers.
That makes sense. All right, any other questions for Leo as we approach the end of the hour?
I got a question. It looks like it came. I'm getting a couple direct questions here. So one question on bundling, right? If you sort of a general question about bundling, you can always, there's nothing wrong with selling two different products at a certain price and then offering sort of a discount when you bundle those together, right? You tell the customer, you buy these two things together, I'm going to sell it to you at a discount because you're buying more from me. What you don't want to do is get into a tying violation, right? So there's something called tying under the antitrust laws where customer really just wants to buy one thing, and you're telling them, if you want to buy this product A, which is the thing the customer wants, you also have to take product B, and product B is something the customer doesn't want. Like if you're tying those things together, that can be an issue if you've got market power over product A, the thing that the customer actually wants. In other words, customer can't just walk down the street and get custom product A on its own, right? Like, so to give an example, if I tell you in order to buy shampoo from me, you have to buy conditioner, not a tying violation because you can go to 1,000 other stores and buy shampoo and conditioner separately. But if I tell you, you can only buy ready mix concrete from me if you buy these concrete blocks and all these other things from me, and I'm the only game in town in a certain county, then we should talk. So that's some guidance on bundling and time. Last question I got here. Is there an established methodology the regulators use to define market in ready mix? So in all of antitrust law, basically antitrust enforcers, courts, parties, the way you define a market is to look at and consider where would a customer turn to for a reasonable alternative or as a reasonable substitute. In other words, if I'm selling ready mix and I raise my price, 100% overnight, to use an extreme example, where would my customers go to buy ready mix instead, right? Who are the providers that go to? How far out would they expand their sort of geographic market? Where would they actually go to get? And that's going to be how you define a market in most cases. Is if I raise my price and my customer doesn't want to pay that price, what are their options? What do they think of as the reasonable options in terms of who are the providers and what is the geography? In ready mix, I think there have been antitrust cases involving ready mix over the years. there's a small radius for ready mix, right? So typically that geographic radius is something like 20 miles. Some cases might have 30, 40, 50-mile radius, something like that. But I think that's what you're going to find in terms of the geographic markets for ready mix based on the cases and enforcement actions that are out there right now.
Leo, there was a follow-up on the bundling, not necessarily about tying products together, but tying projects together.
Oh, I see. Yeah. So if you want us to provide the ready mix for this construction project, we really want to get it for, the next project, and, the pricing might be different depending on whether it's one project or multiple projects. So I think you want to think about that sort of a similar way, in that, what kind of where I would start is, what is your market share and what is your market power, right? If the party you're dealing with doesn't want to do it your way, can they go to somebody else and just deal with them on that particular project? Or can they, what are the alternatives? Or are they basically locked in and they have to accept what you're saying and essentially give you, a really good price for all these different projects? So I think about it kind of the same way, and start with, what is your market share? What is your market power? And certainly, you carry that out to an extreme. You could say, I want the next 20, 30, 40 projects from you. You got to use me for all of them if you want certain things. You got to worry in that situation about foreclosing a competitor. If there's some other ready mix company that's now saying, well, I can't get any of the projects in this county because they're all locked up with, company A, because they've got all these sort of multi-project exclusivity deals, you'd have to worry about that. But I think in most cases, you're probably going to be okay, unless you've got, again, some significant market power, high market share, or some sort of long-term, substantial number of projects involved where competitors really are going to be locked out of a particular market.
Leo, thanks very much. We really appreciate your attention this afternoon. We look forward to continuing to provide additional resources through the Business Advancement Committee on Antitrust to NRMCA members. And Leo, thanks for this presentation. And everyone will hopefully see you all in Vegas. Thank you.
Thanks, Andrew.
Thank you, Leo. Great job.
Thanks, Gary. Thanks, everybody.